Apologetics. A perusal of Dobbs v. Jackson. Leaked abortion case. Written and produced by Pacificatoris. Justice Breyer, Justice Sotomayor, and Justice Kagan dissenting. Supreme Court of the United States. Number 19-1392. Thomas E. Dobbs, State Health Officer of the Mississippi Department of Health, et al., Petitioners v. Jackson Women's Health Organization, et al. On writ of certiorari to the United States Court of Appeals for the Fifth Circuit. June 24, 2022. Justice Breyer, Justice Sotomayor, and Justice Kagan dissenting.
For half a century, Roe v. Wade, 410 U.S. 113, 1973, and Planned Parenthood of Southeastern PA v. Casey, 505 U.S. 833, 1992, have protected the liberty and equality of women. Roe held, and Casey reaffirmed, that the Constitution safeguards a woman's right to decide for herself whether to bear a child. Roe held, and Casey reaffirmed, that in the first stages of pregnancy, the government could not make that choice for women. The government could not control a woman's body or the course of a woman's life. It could not determine what the woman's future would be. See Casey, 505 U.S. at 853, Gonzalez v. Carhart, 550 U.S. 124, 171-172, 2007, Justice Ginsburg, dissenting. Respecting a woman as an autonomous being, and granting her full equality, meant giving her substantial choice over this most personal and most consequential of all life decisions. Roe and Casey well understood the difficulty and the divisiveness of the abortion issue. The court knew that Americans hold profoundly different views about the morality of terminating a pregnancy, even in its earliest stage. Casey, 505 U.S. at 850, and the court recognized that the state has legitimate interests from the outset of the pregnancy in protecting the life of the fetus that may become a child. Idem, at 846. So the court struck a balance, as it often does when values and goals compete. It held that the state could prohibit abortions after fetal viability, so long as the ban contained exceptions to safeguard a woman's life or health. It held that even before viability, the state could regulate the abortion procedure in multiple and meaningful ways. But until the viability line was crossed, the court held, a state could not impose a substantial obstacle on a woman's right to elect the procedure as she, not the government, thought proper, in light of all the circumstances and complexities of her own life. Ibidem. Today, the court discards that balance. It says that from the very moment of fertilization, a woman has no rights to speak of. A state can force her to bring a pregnancy to term, even at the steepest personal and familial costs. An abortion restriction, the majority holds, is permissible whenever rational, the lowest level of scrutiny known to the law. And because, as the court has often stated, protecting fetal life is rational, states will feel free to enact all manner of restrictions. The Mississippi law at issue here bars abortions after the 15th week of pregnancy. Under the majority's ruling, though, another state's law could do so after 10 weeks, or 5 or 3 or 1, or, again, from the moment of fertilization. States have already passed such laws, in anticipation of today's ruling. More will follow. Some states have enacted laws extending to all forms of abortion procedure, including taking medication in one's own home. They have passed laws without any exceptions for when the woman is the victim of rape or incest. Under those laws, a woman will have to bear her rapist's child or her young girl her father's, no matter if doing so will destroy her life. So too, after today's ruling, Some states may compel women to carry to term a fetus with severe physical anomalies. For example, one afflicted with Tay-Sachs disease, sure to die within a few years of birth. States may even argue that a prohibition on abortion need make no provision for protecting a woman from risk of death or physical harm. Across a vast array of circumstances, a state will be able to impose its moral choice on a woman and coerce her to give birth to a child. Enforcement of all these draconian restrictions will also be left largely to the state's devices. A state can of course impose criminal penalties on abortion providers, including lengthy prison sentences. But some states will not stop there. Perhaps, in the wake of today's decision, a state law will criminalize the woman's conduct too, incarcerating or fining her for daring to seek or obtain an abortion. And as Texas has recently shown, a state can turn neighbor against neighbor, enlisting fellow citizens in the effort to root out anyone who tries to get an abortion, or to assist another in doing so. The majority tries to hide the geographically expansive effects of its holding. Today's decision, the majority says, permits each state to address abortion as it pleases. Ante, at 79. That is cold comfort, of course, for the poor woman who cannot get the money to fly to a distant state for a procedure. Above all others, women lacking financial resources will suffer from today's decision. In any event, interstate restrictions will also soon be in the offing. After this decision, some states may block women from traveling out of state to obtain abortions, or even from receiving abortion medications from out of state. Some may criminalize efforts, including the provision of information or funding, to help women gain access to other states' abortion services. Most threatening of all, no language in today's decision stops the federal government from prohibiting abortions nationwide, once again from the moment of conception, and without exceptions for rape or incest. If that happens, the views of an individual state's citizens will not matter. Ante, at 1. The challenge for a woman will be to finance a trip not to New York or California but to Toronto. Ante, at 4, Justice Kavanaugh, concurring. Whatever the exact scope of the coming laws, one result of today's decision is certain: the curtailment of women's rights, and of their status as free and equal citizens. Yesterday, the Constitution guaranteed that a woman confronted with an unplanned pregnancy could, within reasonable limits, make her own decision about whether to bear a child, with all the life-transforming consequences that act involves. And in thus safeguarding each woman's reproductive freedom, the Constitution also protected the ability of women to participate equally in this nation's economic and social life. Casey, 505 U.S., at 856. But no longer. As of today, this court holds, a state can always force a woman to give birth, prohibiting even the earliest abortions. A state can thus transform what, when freely undertaken, is a wonder into what, when forced, may be a nightmare. Some women, especially women of means, will find ways around the state's assertion of power. Others, those without money or childcare or the ability to take time off from work, will not be so fortunate. Maybe they will try an unsafe method of abortion, and come to physical harm, or even die. Maybe they will undergo pregnancy and have a child, but at significant personal or familial cost. At the least, they will incur the cost of losing control of their lives. The Constitution will, today's majority holds, provide no shield, despite its guarantees of liberty and equality for all. And no one should be confident that this majority is done with its work. The right Roe and Casey recognized does not stand alone. To the contrary, the court has linked it for decades to other settled freedoms involving bodily integrity, familial relationships, and procreation. Most obviously, the right to terminate a pregnancy arose straight out of the right to purchase and use contraception. See Griswold v. Connecticut, 381 U.S. 479, 1965, Eisenstadt v. Baird, 405 U.S. 438, 1972. In turn, those rights led, more recently, to rights of same-sex intimacy in marriage. See Lawrence v. Texas, 539 U.S. 558, 2003, Obergefell v. Hodges, 576 U.S. 644, 2015. They are all part of the same constitutional fabric, protecting autonomous decision-making over the most personal of life decisions. The majority, or to be more accurate, most of it, is eager to tell us today that nothing it does casts doubt on precedents that do not concern abortion. Ante, at 66, cf. Ante, at 3, Justice Thomas, concurring, advocating the overruling of Griswold, Lawrence, and Obergefell. But how could that be? The lone rationale for what the majority does today is that the right to elect an abortion is not deeply rooted in history, not until Roe. The majority argues, did people think abortion fell within the Constitution's guarantee of liberty? Ante, at 32. The same could be said, though, of most of the rights the majority claims it is not tampering with. The majority could write just as long an opinion showing, for example, that until the mid-20th century, there was no support in American law for a constitutional right to obtain contraceptives. Ante, at 15. So one of two things must be true. Either the majority does not really believe in its own reasoning, or if it does, all rights that have no history stretching back to the mid-19th century are insecure. Either the mass of the majority's opinion is hypocrisy, or additional constitutional rights are under threat. It is one or the other. One piece of evidence on that score seems especially salient: the majority's cavalier approach to overturning this court's precedents. Stare decisis is the Latin phrase for a foundation stone of the rule of law, that things decided should stay decided unless there is a very good reason for change. It is a doctrine of judicial modesty and humility. Those qualities are not evident in today's opinion. The majority has no good reason for the upheaval in law and society it sets off. Roe and Casey have been the law of the land for decades, shaping women's expectations of their choices when an unplanned pregnancy occurs. Women have relied on the availability of abortion both in structuring their relationships and in planning their lives. The legal framework Roe and Casey developed to balance the competing interests in this sphere has proved workable in courts across the country. No recent developments, in either law or fact, have eroded or cast doubt on those precedents. Nothing, in short, has changed. Indeed, the court in Casey already found all of that to be true. Casey is a precedent about precedent. It reviewed the same arguments made here in support of overruling Roe, and it found that doing so was not warranted. The court reverses course today for one reason and one reason only, because the composition of this court has changed. Stare decisis, this court has often said, contributes to the actual and perceived integrity of the judicial process by ensuring that decisions are founded in the law rather than in the proclivities of individuals. Payne v. Tennessee, 501 U.S. 808, 827, 1991. Vasquez v. Hillary, 474 U.S. 254, 265, 1986. Today, the proclivities of individuals rule. The court departs from its obligation to faithfully and impartially apply the law. We dissent. We start with Roe and Casey, and with their deep connections to a broad swath of this court's precedents. To hear the majority tell the tale, Roe and Casey are aberrations. They came from nowhere, went nowhere, and so are easy to excise from this nation's constitutional law. That is not true. After describing the decisions themselves, we explain how they are rooted in, and themselves led to, other rights giving individuals control over their bodies and their most personal and intimate associations. The majority does not wish to talk about these matters for obvious reasons. To do so would both ground Roe and Casey in this court's precedents and reveal the broad implications of today's decision. But the facts will not so handily disappear. Roe and Casey were from the beginning, and are even more now, embedded in core constitutional concepts of individual freedom, and of the equal rights of citizens to decide on the shape of their lives. Those legal concepts, one might even say, have gone far toward defining what it means to be an American. For in this nation, we do not believe that a government controlling all private choices is compatible with a free people. So we do not, as the majority insists today, place everything within the reach of majorities and government officials. West Virginia Board of Education v. Barnett, 319 U.S. 624, 638, 1943. We believe in a constitution that puts some issues off limits to majority rule. Even in the face of public opposition, we uphold the right of individuals, yes, including women, to make their own choices and chart their own futures. Or at least, we did once. Some half-century ago, Roe struck down a state law making it a crime to perform an abortion unless its purpose was to save a woman's life. The Roe court knew it was treading on difficult and disputed ground. It understood that different people's experiences, values, and religious training and beliefs led to opposing views about abortion. 410 U.S. at 116. But by a 7-2 vote, the court held that in the earlier stages of pregnancy, that contested and contestable choice must belong to a woman, in consultation with her family and doctor. The court explained that a long line of precedents, founded in the 14th Amendment's concept of personal liberty, protected individual decision-making related to marriage, procreation, contraception, family relationships, and child-rearing and education. Idem, at 152-153, citations omitted. For the same reasons, the court held, the Constitution must protect a woman's decision whether or not to terminate her pregnancy. Idem, at 153, the court recognized the myriad ways bearing a child can alter the life and future of a woman and other members of her family. Ibidem. A state could not, by adopting one theory of life, override all rights of the pregnant woman. Idem, at 162. At the same time, though, the court recognized valid interests of the state in regulating the abortion decision. Idem, at 153. The court noted in particular important interests in protecting potential life, maintaining medical standards, and safeguarding the health of the woman. Idem, at 154. No absolutist account of the woman's right could wipe away those significant state claims. Ibidem. The court therefore struck a balance, turning on the stage of the pregnancy at which the abortion would occur. The court explained that early on, a woman's choice must prevail, but that at some point the state interests become dominant. Idem, at 155, it then set some guideposts. In the first trimester of pregnancy, the state could not interfere at all with the decision to terminate a pregnancy. At any time after that point, the state could regulate to protect the pregnant woman's health, such as by insisting that abortion providers and facilities meet safety requirements. And after the fetus's viability, the point when the fetus has the capability of meaningful life outside the mother's womb, the state could ban abortions, except when necessary to preserve the woman's life or health. Idem, at 163-164. In the 20 years between Roe and Casey, the court expressly reaffirmed Roe on 2 occasions, and applied it on many more. Recognizing that arguments against Roe continue to be made, we responded that the doctrine of stare decisis demands respect in a society governed by the rule of law. Akron v. Akron Center for Reproductive Health Incorporated, 462 U.S. 416, 419-420, 1983. And we avowed that the vitality of constitutional principles cannot be allowed to yield simply because of disagreement with them. Thornburg v. American College of Obstetricians and Gynecologists, 476 U.S. 747, 759, 1986. So the court, over and over, enforced the constitutional principles Roe had declared. Then, in Casey, the court considered the matter anew, and again upheld Roe's core precepts. Casey is in significant measure a precedent about the doctrine of precedent, until today, one of the court's most important. But we leave for later that aspect of the court's decision. The key thing now is the substantive aspect of the court's considered conclusion that the essential holding of Roe v. Wade should be retained and once again reaffirmed. 505 U.S. at 846. Central to that conclusion was a full-throated restatement of a woman's right to choose. Like Roe, Casey grounded that right in the 14th Amendment's guarantee of liberty. That guarantee encompasses realms of conduct not specifically referenced in the Constitution. Marriage is mentioned nowhere in that document, yet the court was no doubt correct to protect the freedom to marry against state interference. 505 U.S. at 847 to 848. And the guarantee of liberty encompasses conduct today that was not protected at the time of the 14th Amendment. See item at 848. It is settled now, the court said, though it was not always so, that the Constitution places limits on a state's right to interfere with a person's most basic decisions about family and parenthood, as well as bodily integrity. Item at 849, citations omitted. See item at 851, similarly describing the constitutional protection given to personal decisions relating to marriage, procreation, contraception, and family relationships. Especially important in this web of precedents protecting an individual's most personal choices were those guaranteeing the right to contraception. Ibidem, see idem, at 852 to 853. In those cases, the court had recognized the right of the individual to make the vastly consequential decision whether to bear a child. Idem, at 851, emphasis deleted. So too, Casey reasoned, the Liberty Clause protects the decision of a woman confronting an unplanned pregnancy. Her decision about abortion was central, in the same way, to her capacity to chart her life's course. See idem, at 853. In reaffirming the right Roe recognized, the court took full account of the diversity of views on abortion, and the importance of various competing state interests. Some Americans, the court stated, deem abortion nothing short of an act of violence against innocent human life. 505 U.S. at 852. And each state has an interest in the protection of potential life, as Roe itself had recognized. 505 U.S. at 871, plurality opinion. On the one hand, that interest was not conclusive. The state could not resolve the moral and spiritual questions raised by abortion in such a definitive way that a woman lacks all choice in the matter. Idem, at 850, majority opinion. It could not force her to bear the pain and physical constraints of carrying the child to full term when she would have chosen an early abortion. Idem, at 852. But on the other hand, the state had, as Roe had held, an exceptionally significant interest in disallowing abortions in the later phase of a pregnancy. And it had an ever-present interest in ensuring that the woman's choice is informed and in presenting the case for choosing childbirth over abortion. 505 U.S. at 878, plurality opinion. So Casey again struck a balance, differing from Roe's in only incremental ways. It retained Roe's central holding that the state could bar abortion only after viability. 505 U.S. at 860, majority opinion. The viability line, Casey thought, was more workable than any other in marking the place where the woman's liberty interest gave way to a state's efforts to preserve potential life. Idem, at 870, plurality opinion. At that point, a second life was capable of independent existence. Ibidem, If the woman even by then had not acted, she lacked adequate grounds to object to the state's intervention on the developing child's behalf. Ibidem. At the same time, Casey decided, based on 2 decades of experience, that the Roe framework did not give states sufficient ability to regulate abortion prior to viability. In that period, Casey now made clear, the state could regulate not only to protect the woman's health but also to promote prenatal life. 505 U.S. at 873, plurality opinion. In particular, the state could ensure informed choice and could try to promote childbirth. See idem at 877 to 878. But the state still could not place an undue burden or substantial obstacle in the path of a woman seeking an abortion. Idem at 878. Prior to viability, the woman, consistent with the constitutional meaning of liberty, must retain the ultimate control over her destiny and her body. Idem at 869. We make one initial point about this analysis in light of the majority's insistence that Roe and Casey, and we in defending them, are dismissive of the state's interest in protecting prenatal life. Ante, at 38. Nothing could get those decisions more wrong. As just described, Roe and Casey invoked powerful state interests in that protection, operative at every stage of the pregnancy and overriding the woman's liberty after viability. The strength of those state interests is exactly why the court allowed greater restrictions on the abortion right than on other rights deriving from the 14th Amendment. But what Roe and Casey also recognized, which today's majority does not, is that a woman's freedom and equality are likewise involved. That fact, the presence of countervailing interests, is what made the abortion question hard, and what necessitated balancing. The majority scoffs at that idea, castigating us for repeatedly praising the balance the 2 cases arrived at, with the word balance in scare quotes. Ante, at 38. To the majority, balance is a dirty word, as moderation is a foreign concept. The majority would allow states to ban abortion from conception onward because it does not think forced childbirth at all implicates a woman's rights to equality and freedom. Today's court, that is, does not think there is anything of constitutional significance attached to a woman's control of her body and the path of her life. Roe and Casey thought that one-sided view misguided. In some sense, that is the difference in a nutshell between our precedents and the majority opinion. The constitutional regime we have lived in for the last 50 years recognized competing interests and sought a balance between them. The constitutional regime we enter today erases the woman's interest and recognizes only the states or the federal governments. The majority makes this change based on a single question. Did the reproductive right recognized in Roe and Casey exist in 1868, the year when the 14th Amendment was ratified? Ante, at 23. The majority says, and with this much we agree, that the answer to this question is no. In 1868, there was no nationwide right to end a pregnancy, and no thought that the 14th Amendment provided one. Of course, the majority opinion refers as well to some later and earlier history. On the one side of the 1868, it goes back as far as the 13th century. See ante, at 17. But that turns out to be wheel spinning. First, it is not clear what relevance such early history should have, even to the majority. See New York State Rifle and Pistol Association Incorporated v. Bruin, 597 U.S., 2022, slip opinion, at 26. Historical evidence that long predates ratification may not illuminate the scope of the right. If the early history obviously supported abortion rights, the majority would no doubt say that only the views of the 14th Amendment's ratifiers are germane. See Ibidem. It is better not to go too far back into antiquity, except if olden law survived to become our founders' law. Second, and embarrassingly for the majority, early law in fact does provide some support for abortion rights. Common law authorities did not treat abortion as a crime before quickening, the point when the fetus moved in the womb, and early American law followed the common law rule. So the criminal law of that early time might be taken as roughly consonant with Rose and Casey's different treatment of early and late abortions. Better, then, to move forward in time. On the other side of 1868, the majority occasionally notes that many states barred abortion up to the time of Roe. See ante, at 24:36. That is convenient for the majority, but it is window dressing. As the same majority, +1, just informed us, post-ratification adoption or acceptance of laws that are inconsistent with the original meaning of the constitutional text obviously cannot overcome or alter that text. New York State Rifle and Pistol Association Incorporated, 597 U.S. at Slip Opinion, at 27-28. Had the pre-Roe liberalization of abortion laws occurred more quickly and more widely in the 20th century, the majority would say, once again, that only the ratifiers' views are germane.
To be continued. Par what?
American
Apologetics.
A perusal of Dobbs v. Jackson. Leaked abortion case.
Written and produced by Pacificatoris.
Justice Breyer, Justice Sotomayor, and Justice Kagan dissenting.